International law is the law that governs the relations between states. All right, that's the textbook definition. The question is, what does that mean and what does it include? Now, states in the definition refers not to states of the United States. It's the conventional legal word for what we might call nations or countries. So international law is a system of law governing relations between and among states, means these are the rules that govern the relations between, say, the United States and Canada, United States and Paraguay, or Mexico and Belize. These are the rules. They're international, meaning that they are applicable to relations between nations. International is between nations, and the participants in the system are states, as I say, and that's the term that we're going to continue to use. So don't confuse it with states of the Union. We're in the international sphere. The word has a slightly different meaning. International law is old, certainly dating back to the origins of the nation states in Europe, but presumably, arguably, much older than that. Anytime any two communities that self-identified as separate political entities came into contact with each other, and this would have been true among native nations in North America, there would have been rules for regulating the interaction or disputes that arose between those groups. Might have been warfare, but it might have been all sorts of other things as well. And there would have been rules for regulating interaction between individuals who were citizens of those respective political communities. Of course, as nations, centralized nations, sort of began forming in Europe in the 15th, 16th, 17th centuries, these rules became more precise and more important as trade started emanating from Europe and elsewhere. The need for commercial rules governing what happened when citizens of different countries or trading fleets of different countries came into contact with each other. And then, of course, when the Western Hemisphere was discovered by Europeans, the Europeans suddenly had a need for rules that would regulate their interaction with native peoples, that would regulate their interaction with each other as they discovered sometimes contiguous patches of land or communities or the same. There would have to be rules governing who had what rights to do what. So that in big picture is international law. It was maybe casual at first, and then eventually became a little bit more solid in certain communities, trading communities, for instance, and then would have been written down in treaties or international conventions, or would have appeared in judicial opinions, and over time, as is, I suppose, the nature of things, became much more complex than it had been originally. And now there's, as we'll see, an entire administrative infrastructure based in New York and Geneva primarily that oversees a very complex system of international regulation. And we're going to spend time, as mentioned in the last lecture, exploring that world and seeing how indigenous peoples fit into it and where. Now, these rules govern relations among states, so you might well ask, well, are indigenous people states, and can they participate directly? And if not, then what impact does all of this have on indigenous peoples? The answer is that, for the most part, indigenous peoples cannot participate directly in the sense of full membership, but can participate directly in the sense of active participation rights in negotiations of various instruments, monitoring rights, advisory rights, etc. So while technically not states in either the regional systems we're going to discuss or the United Nations, indigenous peoples are active participants. At the same time, it's important to understand that international law can be enforceable domestically, which is to say that you might think of international law as a means by which Canada can complain that the United States has done something wrong, and then they file suit in an international tribunal and recover some damages against the United States, and that's all true. But at the same time, the US Constitution and the constitutions of other countries expressly incorporate international law into domestic law and make it enforceable domestically. In the US Constitution, that provision is found in Article 6, Clause 2 of the Constitution, which is called the Supremacy Clause, which provides that treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, which is to say, enforceable by the federal courts. So if you have a treaty that's been made enforceable either because it's, and we'll come to understand these terms momentarily, self-executing, or there's been implementing legislation passed, then you can use that treaty to make claims against other parties, against the United States in particular, if your rights under that treaty have been violated, or perhaps against other countries as well through whatever mechanisms the courts allow for these sorts of actions. So there are domestic law implications of international law, and that's true in the United States and elsewhere. So active participation in the system that's creating and monitoring and interpreting these laws, and the opportunity in many instances to use them in domestic lawsuits. All right, now there are two general forms of international law with which we're going to be concerned, or which exist. We're going to be concerned exclusively with one of them. There's public international law, and there's private international law. Private international law is what we also call conflicts of laws. And private international law, conflicts of laws, gives us the rules that apply when individuals or individual entities, corporations for instance, from one country come into conflict with entities from another country, a corporation from another country. And the rules in private international law answer such questions as, where would a lawsuit be tried? In whose forum would it be tried? US court or a French court? And the question, what would the law be that gets applied in that forum? So is it French law? Is it US law? And private international law, which is a whole subfield of international law, deals with how one answers those questions. Public international law, which is what we're going to be concerned with, deals with relations among states at the public level, which is to say the governments of the states, not simply the citizens of the states dealing with citizens of other states. And public international law is also of two general types. There's public international law that's enforceable, and there's public international law that's aspirational. Enforceable means that some objection could be made, the state's not complying with its obligations, and then the question is, well, where do we go under the public international law rules? How do we complain? Who gets to complain, the state or citizens? And what are the remedies? Are there meaningful remedies like orders, or maybe just an admonition, scolding, recommendations for amending behavior? But all of those are methods of enforcement of obligations that states bear under public international law. Aspirational rules are those and commonly found in declarations, as we'll see. They're sort of endgame principles, things that states would really like to be able to say they had done, directions in which states are moving. And we're going to talk about those declarations, aspirational documents, in some detail because, of course, the Declaration on the Rights of Indigenous Peoples falls in that category of international law. Let's first talk about the enforceable side of international law. And here we've got three major sources of international law. The first is custom. Custom is probably the oldest source of international law. It's also the form that's the hardest to sort of get a handle on. Customary international law are essentially the rules that would be analogous to common law rules in the American system. These are the rules of practice that developed over time in relations between states or maybe between other sorts of communities, merchant communities, for instance. And they're really practical solutions to complex problems that evolved over time. So they're common practices. That's one required element of a customary international law rule. And it has to be true that the states, after a period of time, have assumed that they have to do this, that they have to comply with whatever this practice is that's developed over time. I could give you a number of examples. One would be in the merchant setting, which may be where this evolved. So imagine merchants in the Baltic Sea trading goods, and somebody in Latvia buys some product from Germany, and the ship is on its way, and a storm comes up and the ship sinks. Well, question, do they still have to pay for it, the Latvians? Who bears the risk of loss if there's a sudden storm? And there had to be an answer to that. It couldn't be that they would fight it out every time. And so rules developed among the merchant communities where they would just agree, all right, if that's going to happen, then this party bears the loss. And having decided on a rule, they could then price their products accordingly. So if I'm the purchaser and I bear the risk that it's going to sink and you're sailing during the stormy season, then maybe I'm not going to pay you as much for the goods as I would if you were bearing the risk that they would be lost. So there are consequences to these rules, and the communities all agreed to abide by them, and that made for some sort of predictability in commercial interchange. The laws of war are another example. Countries have been fighting each other, states have been fighting each other for ages, and the question is, are there any rules? And of course, the answer is yeah, and some you know. For instance, if you're at the front line and some lone unarmed guy shows up on the hill from the other side waving a white flag, your understanding is you probably shouldn't shoot that guy because he's either coming out to negotiate or the entire force is surrendering. But there is an understood and commonly accepted meaning that it is attached to that gesture. We might ask, well, where does it say that? And initially, there isn't a treaty. It's not like all the countries sat down and executed the white flag rules treaty. It just sort of developed as a practice. Everybody started doing it, and everybody assumed eventually that they were required to do it, that they were supposed to do it, and if they violated that rule, then there would be consequences. Not harming the ambassadors of other countries, another rule that developed over time. If an ambassador shows up, you hear what they have to say, even if you're at war with the country that they represent. So these are what we call customary international law rules. They're going to be important and they're enforceable in courts. They're going to be important in the indigenous law context, as you'll see, because some have made the argument that the UN Declaration on the Rights of Indigenous Peoples is actually evidence of customary international law. And if that's true, then certain provisions of the UN Declaration might be enforceable, because customary international law is enforceable law, not aspirational law. All right. The second of these is something we call jus cogens. Jus cogens, loose translation, compelling law. And the jus cogens principles are things that are generally believed to be so repulsive that no country can participate in them, even if they haven't signed a treaty saying they won't, even if they sign a treaty with another country saying they will engage in these practices. The world community, international law, finds them reprehensible, and so the country can be charged with a violation of jus cogens. Examples of these norms include torture or genocide. You can't sign a treaty with another country in agreeing to engage in joint acts of genocide. It's a violation of jus cogens. Or slaving, by which I mean either enslaving people or engaging in the slave trade. That's a violation of jus cogens norms. That would be a violation of international law by any state that engaged in it. And it doesn't matter whether there's a treaty or not that prohibits the practice. All right. The last of these categories is treaties. And treaties, you're going to see appear under a variety of different names. A treaty, convention is another commonly used word for treaty, usually multi-party treaties. Protocol is a treaty. Essentially what all of these are written contracts. Written contracts. They are agreements reached between states. Within the United Nations system, what will often happen is the General Assembly of the United Nations will introduce a treaty and then invite countries or states to sign on. And that'll be true for the treaties that we look at later. The International Convention on the Elimination of All Forms of Race Discrimination, for instance. And once these states have decided to sign on to these treaties, then they become bound to uphold the rules that are contained in the treaties. And if they don't, then they're subject to whatever consequences the treaties provide. And that will vary from treaty to treaty. Many treaties, including those we're going to focus on, create monitoring bodies, monitoring committees. And those committees are empowered to do whatever the treaty says they can do. The CERD, the Committee on the Elimination of Racial Discrimination, is an example of a monitoring committee created by the ICERD, the International Convention on the Elimination of All Forms of Racial Discrimination. And there are others that we're going to encounter. So treaties are contracts. They're enforceable according to their own terms. That's our three types of enforceable international law. Customary international law, which is practice plus a belief that a state is bound to follow the practice. Jus cogens, which prohibits state conduct regardless of whether there's practice, regardless of whether there's a treaty. And then treaties or conventions or protocols. And those are contracts enforceable under international law according to their own terms. Now, a final word about treaties, because they're important. This is vocabulary primarily. We won't see it applied over much, but it's something you need to be aware of. When a state signs on to a treaty, it's allowed, when it ratifies the treaty, that's the state back home, their government saying, yeah, okay, we agree to be bound by whatever our negotiators agreed to. The state can enter into or include in its ratification reservations, understandings, and declarations. And I'm going to give you examples of each of these, tell you what they are and give you examples of each of these. And these will play a role in the UN DRIP as well, in the US and other states. So a reservation is a provision that says, we like most of the treaty, but we don't like that line. So we're going to agree to be bound by all of it except that line. That's a common form of reservation. And I'll give you an illustration from the International Covenant on Civil and Political Rights. The US reserved, in the following language, that the United States considers itself bound by Article 7 to the extent that cruel, inhuman, or degrading treatment or punishment, which was prohibited under Article 7 of the ICCPR, means the cruel and unusual treatment or punishment prohibited by the 5th, 8th, and or 14th Amendments to the Constitution of the United States. It's a way of saying that's as much as we are going to commit to. If the monitoring body thinks this means something more, that's of no interest to us because we haven't agreed to any more than what we're already bound to do under the U.S. Constitution. An understanding is a state's interpretation of a provision that might be ambiguous. So another example from the U.S. ratification of the ICCPR, the U.S. provides that the United States understands that this covenant shall be implemented by the federal government to the extent that it exercises legislative and judicial jurisdiction over the matters covered therein, and otherwise by the state and local governments. Now, that's a U.S. phenomenon because we have two levels of government, and there is an open question if the U.S. commits to something internationally that it doesn't have the power under the Constitution to enforce locally. It's got to have shared cooperation, shared enforcement cooperation from the states. And so this is its interpretation of the obligations it's assuming to recognize that fact. And if the feds don't have power, the reservation or the understanding continues to the extent that state and local governments exercise jurisdiction over such matters, the federal government shall take measures appropriate to the federal system to the end that the competent authorities of the state or local governments may take appropriate measures for the fulfillment of the covenant. So we'll do what we can, the U.S. commits, if this is an area within exclusively state jurisdiction in our federal system. That's an understanding. And a declaration, an example of a declaration follows this also from the ICCPR ratification. The declaration is that the United States declares that the provisions of Articles 1 through 27 of the covenant are not self-executing. So that's a declaration of this is how we're going to execute this or interpret this document. This is what we're going to do with it, whether you like it or not. A word on self-executing. This part is important. I mentioned earlier that treaties can either be non-self-executing or self-executing. A self-executing treaty is one that takes effect immediately on ratification. Ratification, what does that mean? How are our treaties put together under U.S. law? The Constitution provides that the President negotiates treaties, and that's usually through the U.S. Department of State. Once the treaty terms are agreed to, it comes back to the legislative branch, where the Senate, by a 2/3 vote, has to ratify the treaty. If they can't get 2/3 of senators to ratify the treaty, then it's done. Once it's ratified, though, the question comes up, well, is it self-executing or not? If a treaty is self-executing, that means that immediately upon ratification, it becomes enforceable. If it's not self-executing, then before it can be enforceable domestically, the Congress, House and Senate, have to pass an implementing statute. So they have to actually draft a statute that says, it's now the law of the U.S. that will be bound by the terms of this treaty, and here's what they are. Once implementing legislation is passed, it's enforceable, but until then, it's not. What this declaration said, that the U.S. declares that the provisions of Articles 1 through 27 of the covenant are not self-executing, it's providing notice to the world that this isn't enforceable in the United States until Congress passes implementing legislation, until Congress passes a statute saying, yeah, we're going to do this. And you can understand why that would matter sometimes to Congress, because it's only the Senate that ratifies. If the President and the Senate can put together, agree to the terms of a self-executing treaty, the House of Representatives is completely left out of the process. And so lots of times the House will insist that treaties not be construed as self-executing by including declarations like this, for instance, so that they can have a role in crafting the legislation that's going to then implement the treaty. All right, reservations, understandings, declaration. Those are the three things that can happen to treaties during the ratification process, or prior to ratification, I suppose, and be part of the package that gets sent over. The last international instrument I want to talk about are the aspirational instruments, specifically the declarations. And the declarations are important to indigenous peoples law. The first great declaration of the modern era was the Declaration of Human Rights, adopted by the General Assembly of the United Nations in 1948. Eleanor Roosevelt was a prime mover behind the Declaration of Human Rights. The most important, though, to us will be the Declaration on the Rights of Indigenous Peoples, which we're going to spend a week talking about. That's the first comprehensive international instrument relating to a comprehensive set of rights possessed by indigenous peoples. Declarations, by definition, are aspirational, which means that they set forth goals that states will strive to accomplish. Having said that, as we'll see when we talk about the Declaration on the Rights of Indigenous Peoples, many have argued that certain provisions of declarations, if practiced by states for some period of time, can acquire the status of customary international law. That's certainly been true for various of the provisions of the Declaration of Human Rights, and arguments are now being made and will continue to be made that it's true for various provisions of the Declaration on the Rights of Indigenous Peoples. But as I say, that's a topic that we're going to talk about in detail later.